Have you ever been in a legally confusing situation and weren't sure what to do? Those days are over. Listen to Sabi Law on the Beat 97 ABJ to know what's up. Sabi Law is up every Monday, Wednesday and Friday from 8:55 a.m. Exclusive to the Beat 97 ABJ.
Hello Abuja. This morning on Sabi Law, we are going to be talking on agreements needing signature of notary publics, agreements needing signature of magistrates, or some may tell you, you have to go to the court to get a court clerk to sign that agreement. If not, it is not legal. Mr. Kachi, what do agreements need to be legal and binding?
I know some of our colleagues will not be happy with
at all because
with this episode.
Because it seems we are taking money away from their hands. But well, we have to let people sabi law, even if it means well, we have to say the truth at all times. So Mr. Kachi, go ahead. Please.
All right. Well, basically in Nigeria, an agreement can be written or oral. Now, if an agreement is written, it can be written via text message, email, WhatsApp, or even on a paper, on a nylon, even on concrete wall, anything at all. You can write an agreement anywhere. Now, such agreements are valid and can be tendered it's like you can tender an agreement written on the carton of Bonvita or the carton of any
even
product.
on a tissue paper.
Yeah, you can tender it and the court will see it as an agreement. Now, you don't need your agreement to become valid by taking it to anybody in Nigeria. There is no special person that must sign an agreement for that agreement to become valid in Nigeria. From the president of Nigeria to the chief justice of Nigeria to all the justices, magistrates, lawyers, notary publics, name them, commissioners of oath, not at all. You don't need them or their signatures on any agreement. We are not unaware of the ugly practice wherein some lawyers would let me know, I'm trying to use a good, not an offensive word, but they will just talk to a client and have the client pay them, making the client believe that they are being paid to take the agreement of the client or parties to court for validation. Agreements are naturally valid the moment parties sign them. So the work of a lawyer is draw up an agreement, give it to party A to sign, party B to sign. Agreements are started, is valid. But at times you see these lawyers taking the agreements to some courts. Not even, the ugly thing is that it's not even given to the magistrate or to the court. It's given to a court clerk. Mm-hmm. Some of these clerks are not even with BS. What is BS? Not even with WAEC.
And the funny thing is that some lawyers would not even take it anywhere. They just go and buy a red seal. You know that seal, the red star
adhesive seal.
Yes, and fix to it, and then put their their MBA stamp and seal in there.
So I believe a lawyer should charge well for writing the work so that you don't need to run helter-skelter in a bid to make money under a pretentious manner. It's unprofessional, highly unprofessional. So your take home today is that once an agreement is signed by parties, the people that are making the agreement is valid. You don't need to take such agreements to court for it to be valid. However, I want to also point out two things why some people do this. This is there. Now, there is a condition that when you are doing a land agreement, it is not valid unless the governor of the state where the land is located signs it. My brother, the governor is not in the FCT High Court. The governor is not in a magistrate court. So don't ever take or mistake such governor's consent for any of those things they take there to sign. It's not needed. Another thing is maybe power of attorney. Some people take power of attorney to court because, yes, if it is stamped in court, it is seen as authenticated. But it is only to the extent that signatures that are on such agreements are validly on such agreement. It doesn't mean that tomorrow it cannot be contested. Mm-hmm. So let us not deceive clients under the belief that yes, an agreement only becomes valid when you take it to court to a magistrate and all.
So Agreements will be legal where parties who are adults and sane have agreed on a lawful transaction. Even when there's an illiterate in the agreement, the person write the agreement can just state that there was an illiterate or a blind person. So you don't need to take it to any court person or anything. So please don't let them deceive you. Be empowered, and that's the essence of asking you to sabi law.
And our authority is Section 2. Our authority for this is Section 2 of the Illiterate Protection Act, and also similar laws, including the case of Okafor against Titilokwe 2018. Thank you.
Have you ever been in a legally confusing situation and weren't sure what to do? Those days are over. Listen to Sabi Law on the Beat 97 ABJ to know what's up. Sabi Law is up every Monday, Wednesday and Friday from 8:55 a.m. Exclusive to the Beat 97 ABJ.